Okay, it's 1 p.m. Eastern, and it's time for our webinar. So, welcome everybody. Welcome to CBSR's latest webinar, Beyond Social License: Human Rights and the New Science of Corporate Responsibility. And today we're bringing you this in partnership with our friends at Enodo Rights. And so we have two guests from Enodo on the call today. I'm just going to briefly introduce them. So Yousuf Aftab is the founder and principal of Enodo Rights, a CSR consulting firm that takes a legal risk-based approach to sustainability strategy. He advises companies across sectors on the legal implications of the guiding principles, designing effective corporate responsibility and training programs, supply chain management strategy, and innovative stakeholder engagement. He previously practiced as an attorney specializing in international law at Latham Watkins in New York and Torys in Toronto, and has served as counsel to multinational companies, UN Global Compact, and CBSR. Stephanie Garrett is a senior consultant stakeholder engagement at Enodo Rights and has significant experience advising multinational companies, governments, multilateral institutions, and international NGOs on how to achieve their CSR objectives in the areas of human rights, gender and diversity, corporate community involvement, and cross-sector collaboration. She has worked with companies across the globe to develop human rights guidance and facilitate multi-stakeholder dialogue. She's previously a senior advisor with CBSR. So welcome, Yousuf and Stephanie. Thanks for being here today. Before we get started with the core presentation, just a quick couple of housekeeping items. Inside the WebEx, the Cisco WebEx chat window, if you will, you'll see several boxes. One is the core presentation, which is the lion's share of the screen real estate. You'll also see a view of who's speaking and the panelists. And right beneath that, there are two windows I want to draw your attention to. One, which is a chat feature, which you can use to communicate with both myself and Stephanie during the course of the presentation, if you have any questions, concerns, or technical issues. And then directly below that, there is another box labeled Q&A. And what I would ask you to do, because there are so many people, we have over 160 people registered for this webinar today, is to place your questions for Yousuf and Stephanie in that box there, so we can triage those questions when we get to the Q&A period. It'll just be really helpful for us and helpful for our presenters to keep it all orderly. So, with that in mind, I think we're ready to roll. Do we have, just to check on sound, do we have both Yousuf and Stephanie live on the phone with us now?
I'm here, Steve.
Okay, you sound great. And Stephanie, how's your volume?
Can you hear me?
Yep, I can hear you. So again, if you have any issues with sound or visuals, please just communicate it with us using the chat feature. But you both sound great, and I'll hand it over to you as a starting point.
Excellent. Thanks very much, Steve. And I want to thank CBSR and Stephanie also for organizing this. And thank you all for joining us. So we've entitled this presentation, Beyond Social License: Human Rights and the New Science of Corporate Social Responsibility. And that's for a couple of reasons. One, when we talk about beyond social license, we're talking about a new dimension of risk that's emerging for companies based on their approaches to CSR, and that dimension of risk is independent of stakeholder legitimacy. It's legal risk that's arising. And so we want to speak to the nature of that risk and move to exactly the source of it. And the source of it is where the science part comes in, where emerging business and human rights standards are imposing a structural discipline on corporate social responsibility, and that is what's feeding into the emerging risk. So the structure of our presentation is to go through the nature of this risk, how it is that CSR is evolving from art to science, and exactly what that means in terms of emerging business and human rights standards. And we're going to be focusing specifically in that context on the guiding principles on business and human rights. And then we'll move to what the legal risks are that companies need to be thinking about. And this is focused on not one particular industry in particular, but some of the risks. They are most prominent and most significant when it comes to extractive sector companies, but that risk is flowing far beyond that realm. Then we'll turn to what this actually means in practical terms for how companies should be thinking about their CSR programs, policies, strategy in a way that maintains stakeholder legitimacy while also mitigating those emerging legal risks. And then in the fourth part, this is where Stephanie is going to take over and walk you through an approach to human rights due diligence and stakeholder engagement that is sensitive to these emerging risks and that is built around the guiding principles because they have significant implications for how all of these tools and the processes should be implemented. So turning first to this concept, the evolution of CSR from art to science. Our focus is specifically in this presentation on the guiding principles on business and human rights and their impact on the social dimension of CSR. And so that's the way we're going to be using CSR through this presentation. It's not to say that CSR isn't a vast enterprise. It obviously is, and there are other dimensions. But the focus here is specifically on the social and specifically on how business and human rights standards are redefining how businesses should be approaching the categorization, understanding, and analysis of their social impact. Now, in terms of the art of CSR, what we mean by that is the CSR, to a great extent, has been focused, but still remains focused on stakeholder legitimacy. And that makes all the sense in the world. The entire purpose is to ensure that stakeholders view corporate actions as appropriate, sustainable, respectful of communities and other individuals who might be impacted by those actions. But to the extent it's driven by stakeholder perception, it is a reactive enterprise that's based on what stakeholders believe is relevant, and the company is expected to react to that. But when we talk about the science of CSR, we're talking about a transition that's happening where the scope of business responsibility and the expectations of what business should do when it comes to due diligence and response is driven by standards. There are defined parameters for what a company should be looking at, and it is possible for a company to anticipate what are relevant impacts even before engagement has begun. But there's nothing in what we say today, and hopefully nothing that leads you to believe that stakeholder engagement is not important or that stakeholder legitimacy is not important. Our point is merely that the nature of that engagement is changing, and in addition to stakeholder legitimacy, there is a new dimension, which we might simply call legal legitimacy, that companies need to be thinking about when developing their CSR programs. So what that means is when we come down to it, there are basically three threads that run through this entire presentation. And the first is that the emergence of business and human rights standards has created this new dimension of risk, legal risk, which we will turn to. The second is that there's now a new language of expectation and engagement in the social. It's not simply a matter of understanding what the grievances are, where they're coming from. There's a focus on particular type of grievances, rights grievances, and rights impacts that may not even be grievances. And that's part of the implication of the standards, is that it's not simply enough to respond to what stakeholders might be concerned about. It's important to understand rights impact. And the third part is that this is, as much as this is an opportunity for stakeholders in terms of accountability and precision, it's an opportunity for business. And it's an opportunity for business to create much more efficient and effective and targeted CSR programs and anticipate what the relevant impacts might be. And we'll talk about exactly how that happens a little later on in this presentation. So the standard we're talking about when we talk about business and human rights is the guiding principles on business and human rights. they are the dominant standard, and they're the dominant standard internationally for a couple of reasons. One, it's the only sector-wide, cross-industry set of a framework to understand the responsibility of business for human rights. And then the second is that it's the only rights-wide framework to understand business and human rights. And so, whereas there are other principles, and they might apply in the investment context, they might apply for security, the guiding principles provide a framework that is applicable across the board, and it provides a framework that can apply throughout business operations as well as across sectors. So that's what we're going to be focusing on, and that's the standard that is shaping emerging legal risk. We've listed here a few of the the institutions, both from the public and the private sectors, that have thrown their support and endorsed the guiding principles. But beyond that, there are a number of companies, increasing by the day, who are endorsing the guiding principles or adopting the guiding principles, and this is causing a shift in business practice. Now, the important part, conceptually, what the guiding principles do is give a definition for what it means for business to respect human rights. Because whereas human rights have long been part of CSR, human rights aren't designed to apply to the private sector. So human rights have always been conceived as against the state. So in one sense, when companies would talk about respecting human rights, there was no meaning to that statement without a framework to assess what the steps are to respect. Because the nature of business is very different from the nature of government. And a framework that doesn't, or without a framework, it's hard to know where that responsibility begins and where it ends. And that's what the guiding principles provide. And while they're broad and all-encompassing, in one sense, the guiding principles, when understood properly, can provide guidance for all aspects of CSR when it comes to due diligence and response, when it comes to service provision, supply chain, business acquisition. It's just a matter of understanding what the terms actually mean, but the breadth actually provides for a lot of flexibility. So it's just an overview. The guiding principles, they're built on 3 pillars, but what we're going to be talking about is specifically the business responsibility to respect, which is the second pillar of the guiding principles. And that provides a framework to address social and legal human rights risks using a structured due diligence system. Now, at the heart of the guiding principles is the recognition that states and businesses are different when we talk about human rights. And when we talk about businesses, we're talking about best efforts. The responsibility of business when it comes to human rights is to do its very best to respect them. Now, that is a very different type of responsibility than one would expect of the state. So it's that underlying basis on which the guiding principles lay out the framework. Now, some of this is going to seem a little theoretical and legal, and that's inescapable at this point, but it's just to emphasize that while the guiding principles are not legally binding, they are written like legislation, and they are built on legal concepts, which means that effective implementation depends on unpacking these concepts. So we're going to talk about what that means practically a little later on. At this point, it's simply important to note that there are 3 elements to it. The first legal concept that's relevant are rights themselves. The guiding principles are important because they shift the focus beyond labor rights and beyond one specific subset of human rights, whether that's indigenous rights or community rights or settlement rights, to all internationally recognized human rights. So at the first stage, the scope of the kinds of impacts that businesses need to consider is broadened. The second element is where the guiding principles make this much more precise, make the process of identifying impact more precise and narrow it. And that's by using the concept of causation. So just to draw the analogy once again to the state, states are responsible for human rights within their jurisdiction, over the area that they control. Whereas in order to draw a similar framework for business, we have to recognize that business doesn't exercise that kind of control. And so the way that the guiding principles resolve that issue is to use concepts of causation, cause and contribute to and directly link to. And together, these sort of draw the outer boundary of the types of impacts that companies need to be looking at based on their specific operations. Now, the scope of rights and causation provide the limiting boundaries of the due diligence that companies need to follow. The last part, proportionality, that's where the guiding principles become a little more flexible when it comes to the exact response that's adopted by companies. So whereas it's imperative for a company doing the right due diligence first to identify rights and then look at which ones it may be causing or contributing to an adverse impact on. When it comes to response, there's a process to prioritize based on the severity of the impact and the possibility to look at exactly what the company's operating context happens to be. So the impact ultimately is that this entire system requires more thoughtful consideration in terms of design, but in terms of implementation, it can lead to a much more efficient and targeted and effective process of identifying impacts and mitigating them. Now, the other reason that there are efficiency or effectiveness concerns flowing from the guiding principles is that their widespread acceptance is the source of significant legal risk. So, in terms of that risk, we are well familiar in the CSR space that there are reputational social risks for companies that fail to pay attention to CSR. But what I want to focus on here is that second dimension that's emerging. And with legal risk, what we're talking about is risk that exists independently of whether guiding principles or anything similar becomes part of legislation. If that happens, that's another step altogether, and of course there would be clear legal risk. But at this point, even before the guiding principles are incorporated into law, if that ever happens, they carry significant legal risks indirectly. So I want to talk about two of those under bilateral investment treaties and home state litigation. And the first, bilateral investment treaties, just to give a sense, we're talking here specifically about resource nationalism type cases or foreign interference with an investment in another state. It's bilateral investment treaties. Apologies for those who are counsel and have dealt with this, and it's too basic, but the bilateral investment treaties are treaties entered into between states to protect their investors when they invest abroad. So, for instance, Canada and Venezuela have a bilateral investment treaty. And the purpose of it is to protect Canadian investors when they go to Venezuela and Venezuelan investors when they come to Canada. But so in the case where a Canadian investor builds a factory or opens a mine, starts a mine, exploring and building out a site, if the Venezuelan government happens to interfere or seeks to expropriate that asset, the effect of the treaty is to give the Canadian investor access to international dispute resolution mechanisms. It's extremely important for resource nationalism cases and for the extractive sector, but it's also important for investment in a whole slew of other sectors, including telecoms and finance, and other infrastructure projects and concessions more generally. Now, what's important to note here is simply that in order to access those protections, investors have to show that they have access to jurisdiction, which means their investment was made in accordance with law. Now, this is a term of art, and the only point that's relevant at this stage is that in accordance with law captures principles of international public policy. It captures principles of good faith. It captures the sort of evolving expectation of good business practice. And what that means is the wide endorsement of the guiding principles by the private sector and the public sector alike is likely to filter in to these principles, such that a company that did not do its due diligence when making an investment in accordance with the guiding principles arguably did not respect human rights and therefore doesn't deserve any protection in a situation where the government interferes. There are other heads under which this same requirement, the guiding principles, become applicable, particularly one head, which is that investors also have to show that their investment contributed to host state development, which is also a term that is being interpreted. But there are strong arguments that it incorporates non-economic dimensions. And so an investor that did not respect human rights would not get that protection. The second type of risk to talk about is home state litigation. And here what we mean is a business, let's say a Canadian business operating abroad, that happens to injure someone in its foreign operations could be subject to a lawsuit in Canada based on those foreign actions. And the recent case of Chalk and Hadbay is an example of how the doors are opening to this. We're not going to be speaking about that case at all here or the specific facts of it, but the point to note is that in determining whether a Canadian company would be liable in circumstances like that, courts will look at two elements that can be influenced by the guiding principles and their widespread endorsement. The first is the duty of care, whether that Canadian company owed any duty at all to the foreign plaintiffs. And the second is the standard of care. The guiding principles can influence both. But let's focus right now just on the standard of care, and that's to say the standard of care is what a reasonable business would do. So in a situation where a lawsuit proceeds based on international actions, the question that will be asked is, did the defendant act like a reasonable business in similar circumstances? And that's where the guiding principles become relevant, because their widespread acceptance, both by the private and the public sector, suggests that that's the expectation of business, that when it operates, it is expected to do a certain level of due diligence. And if it doesn't do that due diligence and injury flows from it, then it could be liable in home courts. So in terms of just laying out what the implications of this are, we already know that the social costs of failure to do CSR could be, or to think about stakeholders, could be significant. And of course, in the extractive sector, this has been well documented, but it's also, there are reputational costs across sectors, whether it happens to be apparel manufacturers, certainly following the Rana Plaza incident, whether it happens to be labor supply chain issues such as Apple faced with Foxconn. These issues are constantly being brought into the light, but the legal costs are now arising in parallel. And the difference and the significance is that the legal cost exists independently of how happy a community is. So in certain cases where investor treaty protection has been denied based on failure to act in accordance with law, that means that companies are losing at a minimum tens of millions, perhaps hundreds of millions of dollars. But if they're thinking about it in terms of potential profits, then we're thinking about billions that they may have lost and have no recourse for, simply because the kind of due diligence was not properly implemented. So what does that mean in terms of building a CSR program and strategy that is both focused on stakeholder legitimacy while effectively mitigating these emerging legal risks? And this is a program aligned with the guiding principles is also to be extremely practical because the guiding principles provide a framework for progressive prioritization. That is, ultimately, a company may still end up focusing on a small subset of rights impacts, but the process by which those impacts and that focus is determined is shaped by rights, and if pursued systematically, can allow the company to ensure it is protected against any potential legal risk while engaging effectively and maintaining legitimacy in the eyes of stakeholders. And so the first step of that, to following the three elements of the second pillar, is to define the rights, understand exactly what might or might not be an adverse impact, which has the benefit, and Stephanie's going to touch on this later, but it has the benefit of, one, allowing the company to identify legitimate stakeholder concerns and anticipate impacts, but it also helps to frame the discussion and manage stakeholder expectations from the outset with a focus on a particular type of impact. The second stage is then to apply the causal filter, and once again, this will turn on understanding exactly what the terms mean, but applying the causal filter allows the company to identify the type of impacts that are the responsibility of the company and its marginal sort of contribution to those impacts, and those which are independent of it and which are really pre-existing and haven't been caused by the company itself. And then on the basis of this due diligence, prioritize the response. That is, having identified which rights impacts the company itself is causally linked to, the company can then prioritize based on the nature of the impact and choose a response that turns on its specific causal link and the specific business operating context. Now, in order to do this process, in order to follow this process in a way that is effective, it's important that the company have definitions in place. The reason for the importance of definitions is that these concepts are not self-evident. Human rights themselves are not self-evident, and neither in particular are the concepts of cause and contribute to and directly linked to. And so if a company pursues human rights due diligence without definitions of the rights and without an understanding of the relevant causal links, is in fact not pursuing human rights due diligence at all. It's simply an unstructured ad hoc process, because the only way to ensure consistency is to have in place some guidance. Now, the difference between the guiding principles and ordinary legislation and the difference between businesses and states means that there probably is going to be no definitive guidance on exactly what these terms mean in this context. The important thing is that companies have a consistent and reasonable internal definition. And the importance is both for implementation of an effective program and for justification. That is, the first question, should the legal risk materialize, is going to be, if the company is saying, well, we did conduct the right due diligence, the question will be due diligence on what? And if a company can't speak to what it means when it says cause or contribute to, what it means when it talks about impacts on particular rights, it would be very hard to explain how any given program actually aligned with the guiding principles. Now, the other element of this, and I'm just going to touch on it here because it's a huge topic in itself, is just that, one, as we've mentioned, the definitions of each of these terms are rather complex, and the choices can have significant implications for the scope of the due diligence. So with human rights, for instance, generally they have been defined as against the state. That means that when we talk about the right to life, the right to security of the person, freedom of expression, other liberties, we are talking about a legitimate right that an individual holds against the government. So the first step is to try to understand what that means, to understand how business could possibly impact it. But another element to consider for the business's own purposes in conducting its due diligence is to understand whether there are ways in which now we can think about business itself directly impacting the right. And that will be a process for the business to undertake beforehand as to whether a certain type of impact conducted directly by the business is a rights impact. So just as an example of a difficult issue, freedom of expression, we can understand what that means when it comes to the state. A state, let's say in its simplest terms, ought not to be silencing the people. But if a business signs a confidentiality agreement with its workforce, is that an impact on rights? Probably not, but there might be a point at which a business is directly impacting rights, and it's important for a business to have a sense of what that is. What is inappropriate action? The second part of this is causation. Cause, contribute to, directly linked to, these are difficult terms, and if we just deal with cause, at a basic level, if we used a common test in the law, which is but for, that is, but for a given action, an end result would not have happened, that could potentially expand the range of impacts that are causally linked to the company materially. Significantly. The question is going to be, what are the impacts? If the definition of causation is something else, if it is instead a material increase in the risk of a particular type of impact, or if it is the immediate result of a given impact, these definitions will reshape the ambit of the due diligence significantly. So it's important for a company to have a sense of what that is before beginning the process. Now, what that means is when we come to a guiding principles decision-making process, we would be looking at a number of different issues in a systematic way to identify exactly what the relationship is between the business and any given impact, and then to determine, based on that relationship, what the company ought to be doing. So if we take, for instance, a social impact, as an example, would take an influx of immigrants into a particular region because a factory is being constructed or because a particular project is being started. Now, the influx of immigrants itself is probably not a human rights impact. So that social impact, if we were just following this decision-making methodology, that's not a human rights impact. The question for the business would be whether it wants to address it for social risk reasons, reputational reasons. But elements of that influx could be human rights impact. So depending on the pre-existing infrastructure and the scope of the influx, that may overburden the education system and the healthcare system. And flowing from that, there may be human rights impacts that are related to the right to health, the right to education. So then the question is, for the company that's conducting its due diligence, did I cause or contribute to this impact? am I causing or contributing to this impact, or am I simply directly linked by a business relationship to this impact? So if in this example, the company asking this question is the very company that's starting the project or building the factory, that company then is causing or contributing to the impact. And so we say it needs to avoid or mitigate that particular impact. And we should bear in mind, once again, this is a matter of best efforts. But let's say the company conducting the due diligence is a bank, or it's somewhere higher up, it's a purchaser in the supply chain. In that context, we'd say this company is directly linked by a business relationship to the impact. And so its responsibility is different. Its responsibility is either to exercise what leverage it can in order to prevent or mitigate that impact, to attempt to convince the business entity that is causing or contributing to the impact to stop. Or if it doesn't have that leverage, if it isn't able to influence it directly, it should seek to increase that leverage. So purchasers might unite with other purchasers to come up with a common front. Or banks might talk to other banks, or you bring in government. So the point is, at that stage, it's a matter of seeking to increase the leverage, and that's the exercise of best efforts. But identifying the actual impact and then identifying the causal link provides the decision matrix for the company to decide exactly how to respond. So this leads to the question of organizational structure in attaining this end. In light of emerging legal risks, what is the role for lawyers? How should we fold in lawyers into the CSR strategic process? We'd say there's absolutely an essential role now for counsel in advising on CSR, but that role must recognize the limits of counsel and must recognize the nature of CSR as something that is much more than simply a legal enterprise. But there are three critical reasons why lawyers are important. The first is just understanding legal risk. That is, in CSR programs now, companies are exposing themselves to legal risk when they adopt a policy because they make a statement to the world that this is what we will do. They expose themselves to legal risk if they have a poorly conceived or executed due diligence program. And they expose themselves to legal risk when they report. Because independently of what the international standards are, if they're reporting on complying with a certain standard or another, they open themselves to being held accountable should they not. The second is just understanding business and human rights more generally. And the guiding principles are based on legal concepts. In order to implement them effectively, it's important to have the insight into what those terms mean, and that requires an ability to understand jurisprudence and legislation. And the third part is ensuring privilege, and this is going to be the controversial part of it, because CSR is focused on transparency, and stakeholder legitimacy to a great extent does require transparency. But companies need to be aware that the fact that there is legal risk means that when they collect evidence through due diligence, that could be discoverable in a court of law. That is, if they are sued, they might have to pass over all of their due diligence findings. And that realization is going to make companies more hesitant about conducting rigorous due diligence. The advantage of having lawyers involved at that stage, not necessarily to do the due diligence, but at least to manage it, is that it gives companies a confidential space in which to investigate this. And now this is a pragmatic look at the space. Ideal world, everyone is completely transparent, but the emergence of legal risk, whether we like it or not, militates against transparency. And so this is something that is going to ask for the role of counsel. But CSR is not just a legal enterprise, and it's got to remain focused on stakeholder legitimacy. And so, to that end, there's always going to remain a critical role for those who are experts in engaging with stakeholders, for those who are experts in on-the-ground due diligence, and for those who are experts in reporting. And it's just a matter of recognizing where each role begins and how it fits within the broader framework in light of the nature of the risk. So one model we would recommend is one where legal counsel is involved in designing and managing the process, as whether that's internal or external counsel. And implementation is done on the ground and within the company by independent CSR specialists or internal in-house specialists, but the reporting ultimately on due diligence findings is managed by external counsel. And the reason for that is so that there can be this protected space where a company can be rigorous without exposing itself to undue risk. So with that, I want to turn it over to Stephanie. I have eaten into a little bit of her time, and I apologize for that. But she's going to talk about the practical implications of the guiding principles for human rights due diligence and for stakeholder engagement.
Thanks, Yousuf. So just very briefly, what we wanted to do is look specifically at the topic of, as Yousuf has mentioned, human rights impact assessments and the role of stakeholder engagement. So human rights impact assessments are becoming increasingly recognized as an essential part of the impact assessment process. There's, as of yet, no consensus on integrating human rights into existing social impact assessments or conducting HRIAs as a standalone process. There is actually an ongoing debate about this in this area amongst practitioners who do conduct these sorts of assessments. And I'd be quite interested to hear, if we have time during the question and answer, what participants' experiences are in this and thoughts on it. And there's no consensus on sort of a standardized method for conducting human rights impact assessments either. So at Enodo Rights, we are partial to conducting HRIAs as a standalone process, given that there's a unique objective and unique implications for corporate risk and stakeholder engagement strategies. So conducting HRIA supports a company's process to establish a rights-based approach to stakeholder engagement. Now, this isn't exclusive, but rather complementary to overarching and existing stakeholder engagement strategies and can be seen as an additional and very critical way to engage with stakeholders. So given the objective is to focus on the rights themselves, stakeholder engagement falls differently within this structure. That is, it's not the first thing that a company does, but it's conducted once a preliminary analysis has been done. So if we look here at this slide, at stage 1, we're looking at a baseline assessment, which is essentially a review of the socio-political context within which the company is operating, and then the identification and clarification of what the definitions of rights will be based on that context. So within stage 2, this is based on the decision-making process structure that Yousuf had presented previously, so I won't go into that. And stage 3, which I'll describe in more details following this slide, is about targeted engagement that's rights-focused. And then the final stage, the objective is to amalgamate the business process of defining the rights with the rights and impacts that have been identified through the engagement process with stakeholders. And I'll speak a little bit to how this can feed into regional development planning. So it's important to note that often, unless a company has developed a strong stakeholder engagement strategy and process from the outset of operations, which often isn't the case, stakeholder engagement can often end up being reactive or employing a grievance-based approach, which I think Yousuf alluded to. So this approach focuses on identifying stakeholders with the highest level of influence on the company, those that are most impacted by the company's operations, and then determining their level of support or lack of support in order to establish appropriate engagement strategies and methods. So these strategies are intended to increase the levels of stakeholder support and reduce the risk for future grievance in order to gain or maintain social license to operate. A rights-based approach to engagement, which we, again, have to clarify is complementary to but not exclusive of other approaches to stakeholder engagement, more of a parallel process, begins with the company's identification of rights and business impacts on those rights. It then involves the identification of stakeholders and prioritization of those stakeholders based on the level of potential rights impacts. Stakeholder engagement then becomes a two-pronged process of working collaboratively with stakeholders to define rights and identify both perceived and actual impacts on those rights. So as Yousuf mentioned, what differs between traditional stakeholder engagement approaches, where it is a lot based on perceptions of impacts, this is an opportunity to work with stakeholders collaboratively to identify what their rights are and what the impacts can be. And what's interesting about this is, depending on the stakeholder group that we're talking about, and it could be communities locally, it could be communities abroad in other jurisdictions, can be NGOs, local governments, but the point is that certain stakeholder groups may not even be aware of what their rights are. And so this process is one part about building the capacity of stakeholders to understand their rights, and the parallel process of actually identifying those rights. So it's achieving the goal of ultimately of establishing shared definitions and a shared understanding of rights between the business and the stakeholder group. So the benefit of this approach that we're seeing is that it goes beyond the reduction of business risk. It supports the development of a more targeted social investment strategy for the company, and it can create a foundation for collaborative development of effective grievance mechanisms with the affected stakeholders themselves. Additionally, it can feed into the role that businesses play in regional planning processes, and this is particularly important in jurisdictions or states with weak governance systems where businesses are inadvertently or indirectly playing the role of development practitioners. So what it becomes then is an opportunity for a company to use or employ a rights-based approach to development, working collaboratively with local stakeholders on the ground, thereby reducing business risk and impact and increasing the effectiveness of social investments, which is what we're seeing. So I'll leave it at that because we want to leave room for a question and answer. And Yousuf, I'll give it back to you.
Thanks, Stephanie. So the last slide is, I'm just going to brush over this, but basically at the end of this process, you have a granular understanding of what the impacts are, what's causing them, and ideally an understanding of the processes that are already in place that would mitigate potential impacts so that recommendations can be precisely tailored. And the advantage of sort of this granular and detailed human rights impact assessment approach that's really driven by rights and the guiding principles is to provide a framework that can be reported on no matter the reporting framework, whether it is GRI 4, whether it's ISO 26000 or the Global Compact Report on Rights. It's a matter of, or rather report on progress, it's a matter of having sufficient detail to ensure that the information can be plugged into different frameworks, can be reported on to interested parties, and can be confirmed on a continuing basis. So with that, we will turn it over to questions. Sorry, we will turn it over to questions. And I would just note that I know we've covered a wide range of issues here. We're always happy to discuss, and there are publications on our website that deal with this in a little more depth. But with that, let me just open the floor.
Thanks very much to both of you. What actually we're going to do now is, you'll notice on the screen we're going to post a very quick flash poll. to ask two questions. One, which best represents you in your industry? And I just want to point out an omission. We failed to put in the education sector, so if you could call yourself out in the other, that would be helpful, and we'll read into that. And the other question is, would you be interested in attending a 2-day workshop to learn more about the business and human rights due diligence, yes or no? And we'll just use that to follow up with some of the attendees on today's webinar. CBSR and Enodo Human Rights are looking to put together a series of workshops that could be hosted at your company or your organization. And if you're interested in having us follow up with you on that, then we're happy to do that. And we'll follow up with some more information in the follow-up communication after this webinar. So the poll is live now. So there's the first poll question: which of the following best represents your industry? If you could just select those now. We've got quite a few folks on the call. If you can put your sandwich down from your lunch break for 2 seconds and just give us a quick couple of yes or no's, that'd be really helpful. And the second question is about your interest in attending a 2-day workshop to dive a little deeper into these principles. We've packed a lot into the last 51 minutes, so I appreciate your patience. And this is a subject that was a great interest to CBSR. Yousuf, last year, we did a session on free, prior, and informed consent, which was quite popular as well. I wonder if you could, just as an opening question, maybe call out how emerging frameworks like free, prior, and informed consent versus, say, the current duty to consult that many are using, and how that differs or complements your approach.
Well, no, thanks for picking the most difficult question around, Steve. I think this
Sorry, man.
Well, free, prior, and informed consent obviously is, it's critical when we think about human rights and their impacts, and when we're talking about indigenous rights, rights of vulnerable groups, those are necessarily captured within the analysis. Now, in terms of exactly what that means, with reconciling the duty to consent with the duty to consult, that's still an open question. And so what's interesting is that, the Canadian government has said that FPIC does apply, they can endorse it, and it's consistent with the approach that's been used in Canada, which is effectively saying that Canada interprets FPIC as a duty to consult, whereas obviously there are a number of views out there that would be contrary to this. And at the moment, if we were to say to a company that's operating in Canada, what should we be doing if we want to align with international standards, in light of the lack of definitive guidance on what consent means, I think the default standard is still that which has been applied by the Canadian Supreme Court, that's been considered within Canada to be the norm on consult. But that's only because there isn't a definitive approach on what consent means, or frankly on what free, prior, and informed all mean altogether. So until that crystallizes, the best guidance is to follow the clearer standards that are laid out in Canadian law while operating in Canada.
And I believe that was the consensus of our last webinar, is that this is sent a one-time request. No, it's ongoing. And it changes based on a very regional project versus a project like, for example, like a pipeline that extends across multiple legal barriers and geographies. So it was definitely a challenging, and I realize I lobbed a hard one over the fence at you just now. So we do have some questions coming in through the chat feature on the WebEx. So thanks again to Cisco for offering this service for us. It's fantastic. So this is a question from Kevin. Although there seems to be consensus on the guiding principles, is there similar consensus on what are internationally recognized human rights? I'll leave that.
Yeah, well, to the extent that the guiding principles identify certain instruments, the consensus on the guiding principles, we could say, is a consensus that internationally recognized human rights includes, for certain, the Universal Declaration of Human Rights and its supporting conventions, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. But the guiding principles, at least in the commentary, do speak also to a number of other instruments that would have been passed by the UN when it comes to vulnerable groups. And on that, it's harder to say. And so, for instance, even if there were consensus on indigenous rights, as we were talking about, there wouldn't necessarily be consensus on what those rights mean. To some extent, it would be hard to say that there is consensus on the rights in the Covenant on Economic, Social, and Cultural Rights, in that the positive elements of them, that is to say, duties to provide certain services, it's hard to say that those would be the type that we would consider there to be a consensus around. At the same time, or by case, at the same time, we can say that a company that's doing due diligence should be considering its impact on all of these rights, because the framework of the guiding principles does call for them, and there's consensus on that framework. Now, just this gets to super DG legal level, but just to be clear, it's not to say that because the guiding principles are going to have an impact indirectly through law, that everything that's within the guiding principles would become part of law. So the way it would work is simply as a due diligence standard expected of business, but it's not to say that suddenly a company's failure to provide, let's say, schools would become a violation of the right to education under national or international law. So that's not the mechanism we're talking about in terms of legal risk, but the due diligence part of it would incorporate all of those potential rights that are mentioned in the guiding principles.
Thank you. So I think we have time for maybe one more question. We're trying to wrap up promptly at 2 p.m. Eastern, just out of respect for everybody's time. So I have one more question here. The responsibility for human rights under the guiding principle seems extremely broad. How are companies supposed to implement it, and particularly when it comes to supply chain management, where there are potentially tens of hundreds of thousands of suppliers? How is this handled?
Yeah, so that's another very challenging question. It is something that, on the face of it, the responsibilities under the guiding principles are broad when you look at all human rights, but when implemented systematically, that doesn't necessarily end up being the case. And what we've actually been doing some supply chain work recently for Global Compact, and in that context, I've talked to some leading industry leaders when it comes to supply chain management. The truth is, no one's figured it out entirely. They are struggling with, one, even identifying the suppliers throughout all levels of the supply chain. But the key has been, one, a commitment to the guiding principles of human rights in the first place, and then a process of narrowing somehow. So some companies have adopted an approach where they will focus on particular regions that they know there are relevant impacts. Some will break it down into modules by industry and say that depending on this type of product that we receive through our supply chain, we know that these are the types of rights impacts associated with it. But this is going to be a long-term process. And even the best companies at the moment, they're the best only in their commitment, not in having solved it, because the scope of the supply chain is a vast issue, independently of adding human rights to the mix. Just understanding where your supplies come from is the challenge, but there are ways to break it down that can be more systematic in narrowing the focus to make it manageable as the system is trying to be built out to be comprehensive.
Just one last quick one. We've got 1 minute left. Can you point to some examples where real excellence in implementing a CSR program that aligned with the guiding principles? Any examples you could share with the attendees?
Yeah, I think there are the two companies that I'd probably recommend based on what we've seen. One is Nestle. Nestle has a phenomenal program when it comes both to supply chain and just more generally in terms of focusing on rights and then using a decision-making process that incorporates business risk and rights risk when they come to prioritizing. I don't know if I could say that it was perfectly aligned, but I think it's quite advanced when it comes to the guiding principles. And the other is Repsol. Repsol has a phenomenal program, and in fact, they seem to have moved away from social to treat human rights as the social. But theirs is quite a sophisticated program when it comes to due diligence. I don't know about their supply chain program as such, but I certainly know about their program with on-site assessments, that it's all aligned with the guiding principles. And both Nestle and Repsol have quite a few publicly available materials that cover the nature of this program, and they're worth looking at.
Thank you for squeezing that last question in for us. So we're at the top of the hour. I want to start out by thanking Yousuf and Stephanie for your perspectives and your approach. And again, remind those attending the call today that we will be following up with the slide deck, some additional resources, and we may have an opportunity, if you have any additional questions for us, you can pose them to us via email, and we'll do our best to get those answered. So look for more information on those future workshops if there's interest, and certainly we're getting some chat messages here about it already, so that's encouraging. And I want to thank everyone who attended. This was, by and large, one of the most successful webinars CBSR has hosted in recent years. We don't normally see the numbers, the registration numbers get up quite that high, but I think that means that this is absolutely on point, something that everyone's thinking about, if they're concerned about it, and they need some guidance and assistance. And again, I want to thank Enodo for being here to partner with us on this event and present kind of a fresh perspective. Typically we don't get into the legal weeds very often, and I think it was necessary. And again, I want to thank you both for your time today. Anything else, Stephanie, as far as housekeeping?
I think we're good. I'm just going to send out a link. I mean, we have another webinar happening next week. It's the GlobeScan Canadian Radar, so feel free to register if you're interested. It's happening on Tuesday, same time, 1 to 2 p.m. Eastern. Yeah,
and the GlobeScan Radar report usually covers consumer attitudes towards government, corporations, academia, where the trust levels lie. It always shatters my expectations for how people are feeling about sustainability in business. So please join us for that. It's also one of our most popular webinars of the year. So thank you again, everyone, and look forward to connecting on the next call.
Thanks very much, everyone.
Thank you very much, everyone.
Thank you.